What is a consumer? It's been noted by some that I use various terms on this channel that I don't often explain, although I do try to explain what some of these terms mean. And some people have asked, what is a consumer? In fact, some clients have recently asked, what is a consumer? Because in any kind of contract, it is either a business-to-business contract, or it is a business-to-consumer contract, or indeed it might be a personal person-to-person contract, in which case there's no business involved at all. But in that scenario, is that person considered to be a consumer, or is it just a private contract? That's what I'm talking about today, but first of all, if you're new to me and my channel, I'm a barrister who really enjoys helping you to understand law, so please smash that subscribe button and the bell icon, then you'll get notifications of new videos, because it tells YouTube that you'd like to learn about the law for free from me. And I am going to make a concerted effort to do daily videos on Black Belt Secrets, my sister channel, answering your questions that I often find in the comments. So for now, let's get down to business. And in fact, that's a key term, business, because you would usually think of a business dealing with a consumer. And that is exactly what the law says. You see, in the United Kingdom, we have the Consumer Rights Act of 2015, which came into force on the 1st of October 2015. That means any consumer contract entered on or after that date will be governed by the Consumer Rights Act 2015 and any other legislation to which it refers. Contracts before that date will rely on the old legislation, but for the purposes of this video explaining what is a consumer, I'm going to focus on the 2015 Act and how that applies today. As with most pieces of legislation, this Act contains definitions as to what it refers, and therefore it also deals with when this Act applies, and in other words, to which contracts this Act will apply. And we're going to deal with those in reverse order, because Section 2 deals with the definitions of what is a trader and what is a consumer. And it's a distinct difference which will help you to understand when this Act applies, what rights it gives you, which I will come back to a little bit later, and in doing so help you to understand what a consumer is in the eyes of the law. So in Section 2, it provides you those definitions as follows. A consumer means an individual acting for purposes that are wholly or mainly outside that individual's trade, business, craft, or profession. So there it is, a very succinct and precise definition of what the law says a consumer is. It is a person that is acting outside of their trade, outside of their business, outside of their craft, or outside of their profession, either wholly or mainly. And it's this word mainly that creates a little bit of an overlap, and I'll explain what I mean. For example, as a barrister, which is a profession, if I were to buy something that was mainly, or wholly, as the Act suggests, outside of my profession, so I'm using it mainly for my own personal uses, rather than the profession of being a barrister, then I'm acting in a capacity as a consumer. Whereas if you were to contrast that and I were to buy something that is 100% to be used for that profession, then I am not any longer acting in the capacity of a consumer. Rather, I'm acting in a business or professional capacity. So the overlap will be if you can use something for your professional capacity, but you also use it in your personal capacity. But in that context, whatever it is that you're entering a contract for, you are dealing mainly in your capacity outside of your profession, then you will be considered to be a consumer. A trader, on the other hand, referring to any business, is also defined in Section 2 of the Consumer Rights Act and is defined as a person acting for purposes relating to that person's trade, business, craft, or profession, whether acting personally or through another person acting in the trader's name or on the trader's behalf. And so that's quite clear. Someone acting as a trader is someone that is acting in a business, a craft, or profession. So in other words, they are not acting in their own individual capacity. So this applies to most businesses that are dealing with someone who is buying something for themselves. So if it is a person or a business that is selling something to an individual that is using it for themselves, then obviously there is a trader-consumer relationship there. But how about the scenario where the trader is trying to say that the consumer was not acting in the capacity of a consumer? In fact, that person was acting in the capacity of a business, trade, or craft, or profession. So that is where subsection 4 of Section 2 of the Act kicks in, which states as follows. A trader claiming that an individual was not acting for the purposes wholly or mainly outside that individual's trade, business, craft, or profession must prove it. So quite clearly, the burden is upon the trader to prove that the individual was not acting in the capacity of a consumer. This is something that comes up fairly frequently. Why? Because if a person is acting indeed in the capacity of a consumer, they have the protection, and it is protection, which I'll explain in a moment, of the Consumer Rights Act. And that protection comes from the fact that it is a rights-based piece of legislation, which is quite important. So in some situations, the trader might seek to say that the consumer was acting in the capacity of a business and therefore different rules apply. Business to business law, which is very different to that dealing with a consumer. And so that will bring me on to precisely what rights are afforded to a consumer acting in this capacity under the Consumer Rights Act. But before I do that, let's just jump back a moment and look at Section 1 to see which contracts this applies to, which is indeed quite broad. Section 1 reads as follows. This part applies where there is an agreement between a trader and a consumer for the trader to supply goods, digital content, or services if the agreement is a contract. And importantly, it applies whether the contract is written or oral or implied from the parties' conduct, or more than one of these combined. So essentially, where there is a contract in place for goods, digital content, or services between a trader and a consumer, this act and the rights therein kicks in. This act does go into a bit more detail as to which contracts are covered, but I will cover that perhaps in another video. And to that end, there are a couple of primary sections of this act. Section 9 of the Consumer Rights Act implies a term into any contract, and what that means is even if this term wasn't written down in the contract, it will be a term of the contract because it is implied by law by the Consumer Rights Act, and the trader cannot do anything about it. The trader cannot say that the Consumer Rights Act doesn't apply to the contract. That is simply an unenforceable term. Section 9 states that goods are to be of a satisfactory quality, and specifically, every contract to supply goods is to be treated as including a term that the quality of goods is satisfactory. And this will include any description of the goods, the price or consideration of the goods paid if that is relevant, and all the other relevant circumstances. Subsection 3 also provides that the quality will cover the fitness for all the purposes for which goods of that kind are usually supplied, the appearance and finish, freedom from minor defects, safety and durability. And there is a lot more to Section 9, which again I'll go into in a lot more detail. This is an overview of what rights are afforded to a consumer under the definition of a consumer. Section 10 is another key part of the Consumer Rights Act, which implies the term that goods are to be fit for a particular purpose. And this is very important because if the consumer tells the trader that the product needs to do a certain thing, there is a term implied to that effect. Under subsection 3, the contract is to be treated as including a term that the goods are reasonably fit for that purpose, whether or not that is a purpose for which goods of that kind are usually supplied. In other words, it matters not if these particular type of goods are usually supplied for that particular purpose. If the consumer's made it known to the trader that this is what it's to be used for, and the trader agrees that it's good for that, then there is a term implied that it should be fit for that particular purpose. And if not, it's a breach of contract, which I'm going to come back to in a moment. Other sections, such as Section 11, provide that goods are to be as described. This might be by way of a description or by way of a sample, and it must match that sample. It is no good, as subsection 2 provides, that most of it matches the sample but doesn't match the description. Subsection 2 provides, if the supply is by sample as well as by description, it is not sufficient that the bulk of the goods matches the sample if the goods do not also match the description. So these sections and various other sections of the Consumer Rights Act provide that terms are implied into a contract with a trader on behalf of the consumer. The reason for this is with respect to lay consumers, they may not know which terms ought to be implied in order to protect them in the capacity of a consumer when their purchase really ought to be protected in law. What this ultimately means is, if any of these terms are broken, such as the goods are not of satisfactory quality, they're not fit for the particular purpose that the consumer made known to the trader at the time, or the goods don't match the sample, they don't match the description, and so on. If any of these things apply to whatever it is that the consumer has purchased, whether that is goods or services being covered later on in the Act, then this would likely amount to a breach of contract and the consumer would be entitled to damages as a result. Damages arising out of the breach of contract. And because I seem to have lost part of the file where I actually talked about the rights in the Consumer Rights Act, I'm going to do that again now, although now you get my GoPro and a slightly different surrounding. So Section 19 of the Consumer Rights Act provides a right for consumers to enforce the terms about the goods into which they've entered a contract for. So Section 19 provides that it is a right for consumers to enforce the terms such as implied by Sections 9, 10 and even 11, 13 and 14 and so on, as you can see in Section 19. And if that contract does not conform to those sections, in other words, satisfactory quality and fit for purpose and so on, then it provides that consumer additional, such as a short-term right to reject. And this is provided under Section 20. Under Section 20, a consumer has a short-term right to reject goods under a contract if they do not conform to the contract and the terms set out in the Consumer Rights Act. And this is exercised under subsection 5 of Section 20, that this right is exercised if the consumer indicates to the trader that the consumer is rejecting the goods and treating the contract at an end. And this goes on to say that the indication may be something that the consumer says or does, but it must be clear enough to be understood by the trader. So in other words, if the consumer says to the trader, "This is rubbish, I want my money back," that would be sufficient under Section 20 to exercise the short-term right to reject. Now, it's important to remember that there is a time limit for the short-term right to reject under Section 22. Now, this is when ownership has been transferred and when the goods have been delivered and so on, as set out under subsection 3 of Section 22. But a question that comes up a lot is, what if there is a defect to the product and the consumer agrees to a repair or a replacement, but there's a waiting period until such repairs have been carried out? Now, most traders will think, wrongly, that if 30 days passes, and even if the repair hasn't been carried out, that the consumer has lost this short-term right to reject the goods under the contract because 30 days has passed. But that's not true, because if we look to subsection 6 of Section 22, it states that if a consumer requests or agrees to the repair or replacement of goods, the period mentioned in subsection 3 or 4 stops running for the length of the waiting period. Now, this might often come about if you've bought a car and then you realize that there is actually something wrong with the car. You take it back to the dealer or the garage and they say, "Don't worry, we will put it right and we'll do the repairs." But the repairs actually take 3 or 4 weeks, and by which point, you having had the vehicle for a week or two, you then ask the dealer whether the repairs have been carried out. The dealer says, "Well, no, they haven't yet, but we're still working on it," by which point 30 days has already elapsed. The dealer may then be under the incorrect assumption that you can no longer reject the vehicle under the Consumer Rights Act because that short-term right to reject has elapsed. But that's wrong for 2 reasons. First of all, subsection 6 provides that the waiting period puts this short-term right to reject on hold. Therefore, if the repairs still have not been carried out, you still retain that short-term right to reject. The second reason it's wrong is because if a defect is found within the first 6 months, either from the purchase or from the 30 days, it matters not, up to 6 months, the defect is taken to be there at the time of purchase, and it is the trader that would have to prove that this defect was not there at the point of purchase. This burden shifts after 6 months. So after 6 months, it is the consumer that has to prove that it was there at the point of purchase. But this is just how those time limits work. And there is also, if you look further at Section 23 under the Consumer Rights Act, there is a right to repair or replacement, and these various rights are enshrined in the Consumer Rights Act. Traders cannot exclude them from a contract. That would be unlawful. So now that I've done this additional clip that I seem to have lost somehow, back to the video. So on a number of occasions I have seen the arguments that two individuals selling something to each other, one believes that they're acting in the capacity of a consumer, whereas that might not be the case if it is a wholly private sale. On the other hand, if one of the parties selling the goods or the services has entered into some kind of business, trade, craft, or profession, they will meet most likely the definition of a trader under this act, and the other party will benefit from the protection as a consumer under the Consumer Rights Act. Similarly, I've seen businesses trying to say that the individual was not acting as a consumer and in fact they were acting in the capacity of a business, perhaps due to conversations that have been had between the parties at the point of sale. Now, it matters not necessarily what those conversations were. What really matters is the actual final execution of the contract reduced to writing. This is going to evidence what the parties agreed, between which parties it was agreed, and any other terms that the contract seeks to incorporate. But remembering all the time that if the trader seeks to exclude the Consumer Rights Act from the contract, it will matter not if it is deemed that the individual was acting in the capacity of a consumer. And remember, if the trader says that they were not acting in the capacity of a consumer, it is the business or the trader that must prove it. As to a bit more detail about consumer rights, I've covered this in other videos before, which I will link in the description below, and you can go and watch that video next. So in the meantime, I hope that has helped to understand what a consumer is. Give this video a thumbs up if it's been helpful, and remember, stay humble and subscribe.